Hi, everyone. Today was the final day of the Supreme Court's term, and we have some more big decisions after uh, a major term in which they overturned a lot of longstanding precedent, created a lot of new troubles for people across the country, and raised a lot of troubling concerns about the future of the judiciary and the executive. Uh, that's my point of view, but I think that I am in good company in saying that. I'm very glad today that I am bringing you an analyst and an expert who gives us not just perspective, but a sense of calm, because I know a lot of you feel quite anxious about what all of this means for our future. And I like to remind you that information is power. You're learning this so that you can be informed to do something, take action in your communities, and especially around election time. So Today's guest is Steve Vladeck. You probably already know him if you spend time on Substack. He has a fantastic newsletter that is called One First. It's about the Supreme Court. He is a law professor at Georgetown University, specializes in federal courts, constitutional law, I think national security and military law. He's our guy. Steve, thanks so much for being here today. I'm sure you are like the most in demand you can possibly be.
Happy to be with you, Jessica. It's a busy day, but all the more reason to help folks break down why it's so busy.
Yeah. Well, let's start with the big decision from there are a number of big decisions from the court, but let's start with birthright citizenship.
Yes.
I guess overturning a constitutional guarantee by executive order was one step too far, even for this court. Would you break down for us what was the court's reasoning and what does this now put to rest?
Yeah, I mean, one step too far, but man, it was a near-run thing. I guess, I had walked out of the oral arguments back in April thinking that this was actually going to be pretty decisive and emphatic. And, we got emphatic. We didn't really get decisive. I mean, the court ruled 6-3 that President Trump's executive order is unlawful. And so that was clear. And it was Chief Justice John Roberts, joined by Justices Brett Kavanaugh, Amy Coney Barrett, and of course, the three Democratic appointees. But Jessica, what's striking is that on the constitutional question of whether the citizenship clause of the 14th Amendment means anyone born in the United States, with some very, very, very narrow exceptions, is entitled to citizenship, the court split 5-4. I mean, Justice Brett Kavanaugh, sort of peeled off from the Roberts majority on that. And I guess, I'm not surprised by the majority opinion. I mean, it said all the things we expected, that this was the original understanding of the citizenship clause when it was adopted in 1868, entirely to overrule the Dred Scott ruling. This is how the Supreme Court interpreted the citizenship clause in 1898. And yet, right, that only mustered 5 votes on the Supreme Court. And I think that's, a sign of just how far things have moved and just how conservative this court is, that what really should have been a no-brainer and perhaps even an institution credibility generating ruling ended up the way that we got.
In addition, as you noted, 3 justices dissented. What was their argument? And I don't know, how significant is it that 3 justices on the U.S. Supreme Court were prepared to overturn a constitutional guarantee?
Yeah, I mean, so the Justice Thomas wrote 91 pages, one of the longest dissents we've actually ever had in the Supreme Court. There were a couple of different threads in the dissent. So one was this deeply misbegotten view that the language of the citizenship clause, by referring to individuals who are subject to the jurisdiction of the United States, is actually incorporating some idea of allegiance, and that, there are plenty of non-citizens who are physically in the United States who don't owe allegiance to the United States. That ruling had been, or that reading had been, really soundly discredited by the scholarship, and yet it's enough for some of the justices. There were others who focused on the sort of domicile point, that really it was a question of whether you were domiciled in the U.S. Had you come to the United States for the purpose of living here permanently, versus like, are you a tourist passing through? And I guess, Jessica, what's so striking about these arguments is that they play so fast and loose with the very kind of methodology that the conservative justices typically tell us we should all embrace, this, originalism. What was the original public meaning? And yet you see in these dissenting opinions policy arguments, right? And you see in these dissenting opinions sort of counterfactual or cherry-picked history that I think is really hard to swallow, especially coming from justices who say that's how we're supposed to interpret the Constitution. So really, I mean, that's to me the disheartening part of this otherwise positive headline, which is that you had 3 justices, and really, if we count Justice Kavanaugh, at least on the Constitution, 4 right, signing off on that view.
You might not have an answer to this, but I'm curious. Is there anything that this now opens the door to? When you take the Kavanaugh
Yeah.
opinion plus the dissenters, does that give us a window into what else they might be leaning, this might lead us toward?
Maybe. I mean, so let's start with it's still a dissent. But Justice Kavanaugh sort of all but says in his separate opinion that Congress, in his view, could try to codify President Trump's executive order by statute. Now, that would lose on the current court, but it would lose 5-4. And so I think it's more, Jessica, a placeholder for what happens if the court's composition changes, right? That if you had one justice who's currently in the majority, whether it's, Roberts or Barrett or Sotomayor or Kagan or Jackson, replaced by someone appointed by President Trump, now you have a lot of room, maybe not for the president, but for Congress to really go back on what I think a lot of us had thought were long settled understandings of the Constitution's guarantees of citizenship. And that to me is the sort of the dark underbelly of today's ruling, which is it's the right result, but with a lot of ominous warnings about what could happen with just one small shift in the trajectory of the Supreme Court.
This is just an aside, but Speaker Johnson was holding a press conference when the decision came down, and a reporter read it to him and asked his reaction. And his first thought was, well, I guess you could argue that was an originalist interpretation of the Constitution, but it's terrible. So it just gives the lie to that whole posture that that's really what this was always about, as opposed to seemingly driving certain outcomes. I want to ask you about immigration more broadly, because the decision today does not mean that the court is jettisoning Trump's overall immigration agenda. In two other major decisions this term, it allowed the administration to turn away asylum seekers at the border and to strip legal protections from hundreds of thousands of Haitians, and Syrians. Those are the two I can remember. Maybe there were others. When you take these together, what do these rulings open the door to? And are the justices effectively allowing the administration to sort of set aside immigration law when it evokes presidential authority?
Yeah, I mean, I think this is such an important point that if we actually look at the whole sort of run of immigration decisions by the Supreme Court this term, the birthright citizenship ruling ends up looking a bit small. I mean, the numbers you mentioned in the Haiti and Syria case, that's just for those two countries. If you actually expand it out to all of the countries where the Trump administration has sought to revoke temporary protected status, we're talking about more than 1.5 million people in the United States. Who could be overnight, right, subject to arrest, deportation, removal, who wouldn't have been before last Thursday's ruling in Mullen versus Doe. The asylum at the border case, Mullen versus Alotro, I think a quietly important decision that also, I think, gives this executive branch a heck of a lot of power. Jessica, when folks who are entitled to asylum, present themselves the way they're supposed to at a port of entry along, say, the Mexico-U.S. border, now the government can just say, go away. There's a sort of a smaller ruling that came down last week that's in the same vein called Blanche versus Lau. This was about green card holders who leave the country and then what immigration officers can do to them when they try to come back in. Right? Like, this is all, I think, a much darker side of the story where this court has enabled a lot of the administration's, I would say, more aggressive interpretations of the relevant statutes. I think the Democratic appointees who dissented in all of those cases have the better of the arguments, but that's where Trump went too far in the birthright case, right? In the asylum case, in the TPS case, in the green card case, it is a contested interpretation of a statute. In the birthright case, it's Trump saying, to heck with the statute, I should be allowed to do this, period. And I think that's why you see the distinction between the court enabling the former and pushing back on the latter.
Right. So they're enabling the maximalist interpretation of executive power inside the law. They're not ready to roll back actual constitutional protections.
Which, of course, but I think the tricky part there, Jessica, and you know this as well as anyone, is that would be easier to swallow if the court had been just as maximalist when it came to executive branch interpretations of statutes when the president just happened to be a Democrat. Yeah. And yet, you think about the student loan case, or you think about, the Affordable Care Act case during the Obama administration. The court has not shown the same kind of statutory deference to presidents to Democrat presidents that it's shown to this president. I think that's where we get to the broader theme of this term, which is a court that is not in the bag for President Trump. Look at the tariffs case, but a court that has moved so far to the right and has been nudged so far to the right by this administration.
Another example of that today is the campaign finance ruling, which is tectonic. It's an enormous change to campaign finance law. For anybody who doesn't know, they essentially struck down limits on how much political parties can spend in coordination with candidates, I believe.
Yep.
Help explain this. And also, I think this opens the floodgates for billionaires, corporations, special interests to buy influence. How do you foresee this changing American campaigns?
Yeah, I mean, this was one of the last sets of meaningful campaign finance restrictions from the 1970s era statute that was still on the books. Jessica, part of why it was still on the books is because in 2001, not that long ago, the Supreme Court had expressly rejected a constitutional challenge to those limits in a case that's known as Colorado 2 in shorthand. And what the court did today is it overruled Colorado 2. And what's striking about that is you had already political parties that were allowed to raise money on their own, and you have candidates who are allowed to raise money on their own. And the idea was that by keeping those avenues distinct, you avoided this concern. You avoided this quid pro quo. Hey, RNC calls a candidate. If you support this, this, and this, we'll throw all this money at you. Right? That was designed to push against that, to have candidates raising money on their own and not depend upon the parties. That's now gone. And so I think it's not just about how it opens the floodgates to more money, Jessica, in these elections. It's about how it reduces the ability of individual candidates to be rogue, to be independent, right? To go against the party, or even just to not sort of tout the party line, because they will now be dependent upon the much larger campaign coffers of the parties. And that's not just Republicans. Democrats will do it too. And it's all in service of, this agenda that like all campaign finance regulation is, like this massive First Amendment violation.
It's insane. First of all, does it allow for coordination?
Yes, now it does. So the whole point of the limits was to not allow coordination. So what the court struck down are what's known as the coordinated expenditure limits. And those are now gone. So yay, coordination.
So for anybody who's not familiar with this, essentially what happens is you've seen all these super PACs grow since Citizens United, but the limit on super PACs was they couldn't actually coordinate with a candidate to say, for example, we're going to handle all the messaging around housing in your community.
Right. Or we'll do the attack ads, you do the happy ads.
Even better, yes. And before you had to do it separate, so the campaign couldn't coordinate with the outside money on how that would work. Now it's just another pool of money effectively for the campaign, because you could get billionaires coming in saying, I'll give you $50 million in attack ads. So is there, go ahead.
No, please finish, please. I cut you off.
Is there any firewall left when it comes to campaign finance?
A little bit. I mean, there are still some limits on how much candidates can spend, right? There are still some limits on how much people like us can contribute. But the reality is that now it's just sort of, stacking sandbags, where it's really only sort of, each party trying to maximize their war chest. And I think this gets back to, to me, this dovetails with one of the other real stories of this term, which is the partisan gerrymandering wars, which is that when you add these things together, they're swimming in the same direction, where it's giving the parties a lot more power. It's giving the parties a lot more of an ability to sort of, sideline those who might, dare to be independent and cross over and like work towards compromise. And it's basically, Jessica, moving us to a point where primary elections are becoming so much more important across the board than general elections, which just means that the Democrats who are electing are going to be further to the left, and the Republicans who are electing are going to be further to the right. And when we look at Congress and say, why can't they get anything done? Why is there no middle in Congress, right? These are all of a piece with that. And we tend not to blame the Supreme Court, but maybe we should, right? Maybe the court actually bears a lot more responsibility for our institutional dysfunction than we might, think at first blush.
Yeah, I hear constant complaints from the audience. Why isn't our government more representative of what the broad majority of Americans want? One reason is gerrymandering, and these rulings made it worse this term. But the other is the influence of money in politics because, billionaires, now trillionaires, tech CEOs can have enormous sway because they have this ability to finance campaigns almost in a limitless way now. Um, I could talk to you about this for the entire day. I want to get on to another really important ruling. This has to do with trans athletes, and the court upheld state bans excluding transgender girls and women from female sports. Would you explain the broader legal argument? And also, is there a way in whatever they ruled could be used to create limitations on what trans individuals have a right to access when it comes to other spaces, schools, workplaces, or sex segregated environments?
Yeah, I mean, there's a lot here. So the first thing to say is that the cases the court decided today in a single consolidated opinion really were just about athletics. And, Justice Kavanaugh's majority opinion tries to sort of toe that line and say, we're just deciding the sports question. But of course, how can you not ask, right, what comes next? And so here's where the mechanics matter a bit. On the constitutional question of whether West Virginia and Idaho, the two states at issue, were discriminating against transgender women on the basis of sex, the court actually said, yes, right, this is sex-based, and therefore the states had to have a special justification. They had to have a better argument for treating transgender girls and women differently than any old regulation. The problem is then the court said, but here the states have that argument. And so, Brett Kavanaugh talked about the safety concerns when it comes to transgender girls and women playing in girls' sports. He talked about the fairness concerns. And he said that those are, in the constitutional doctrine language, important governmental interests to which the sports bans were substantially related. That's the language of intermediate scrutiny in con law world. I guess I'm struck in two respects by that. The first is this is a pretty weak form of intermediate scrutiny because we weren't that skeptical of how much this really is the state's interests. When you talk about how few transgender girls and transgender women were playing on these teams, hard to see the state's interest as being as strong as Kavanaugh says. But second, when we think about the next generation of cases, now it means, right, if a state excludes transgender women from girls' bathrooms, for example, they'll also have to meet this higher, intermediate scrutiny standard. Is that going to make it a little bit easier for those plaintiffs to bring those kinds of claims? Or are courts going to have the same kind of wishy-washy, this looks pretty important on the state side? That to me is the disheartening part of the ruling, is just how non-critical, right, the majority was of how important the state's interest really is.
I have a feeling I'll be talking to you about this again next term. Is there a case next term around transgender
So there's
athletes?
already one about transgender students who run away from or transgender children who run away from their parents, which the court added to the docket yesterday. I mean, one of the things we're seeing in the transgender rights context, we're also seeing this in the Second Amendment context, is the court takes one of these big cases a year and moves the needle, in one direction or the other, although of course increasingly that direction is to the right.
Well, and I heard they're going to consider us over the ban on semi-automatic
on AR-15s.
Okay. We're going to put that to the side for now. I only have a few more minutes with you, and I want to step back and take a bigger picture look at this past term. When you consider their rulings on voting rights, the expansion of executive power, campaign finance rulings, and the broader business-friendly record we're seeing from them, I'm curious, what larger project do you see here? And to ask what in your profession is called a leading question, is the court steadily shifting power away from voters and individual Americans toward corporations, wealthy interests, and the president himself?
So, I mean, the answer to all those things is yes, but I think the real institution that the court is shifting power toward is the court. And, that comes through in lots of cases, even the ones where Trump is losing. I mean, maybe most visibly in the ones where Trump is losing, where, this is a court that loves executive power, but only to a point, not for the Federal Reserve, right? This is a court that is okay with expansive readings of immigration statutes, but not tariffs. Right? That it is because there isn't necessarily a coherent set of principles that explains why A but not B, that I think the real thesis is this is a court that is invested principally in its own power. And, Jessica, what's striking about that is that is a, that is a self-defeating proposition in the long term. Because if they're only interested in their own power, more and more Americans are going to say, well, why do we give these guys power in the first place?
Mhm.
And that's, there are reasons why the court at this moment isn't looking over its shoulder. But that can change pretty quickly. And I think we're seeing, especially with the redistricting cases, just how much court reform has become a
Yeah.
more dominant topic in, political circles. That's not good for the Supreme Court in the long term. And so I think the question is, what is it going to take to get this court to actually realize that it is continually eroding its credibility among an ever larger group of Americans? Because once you go past the point of no return on that, I'm not sure how we get it back.
Mm. I saw an NBC poll that showed, I think it's 22% of Americans have confidence in this court, just 22%, down from 50% when they started the poll in the year 2000.
And this is a court that depends upon diffuse public confidence for legitimacy. I mean, the reason why presidents comply with Supreme Court decisions is not because John Roberts is marching up Pennsylvania Avenue with a bunch of marshals, right? It's
Right.
because of the political consequences a president would face for defying the Supreme Court. The more unpopular the Supreme Court is, the lower, the fewer, the less the consequences will be if and when a president really were to say, you've made your decision, Supreme Court, now let me see you try to enforce it.
Steve, you're fantastic. Thank you for your clarity and compassion in the way you explain all this. I would absolutely love to have you back if we could do another conversation sometime about looking back on the court's rulings related to elections and campaigns themselves.
I love that.
Can,
Thanks for
can we
having me,
do that?
Jessica.
Great. I'm going to remind everybody to read his Substack and check him out everywhere. Everywhere Steve Vladeck appears. Have a wonderful rest of your day. Thanks for being with us.
Thank you.
Bye. And to everyone watching, I'm going to send this out in Substack as a newsletter later today. We'll post it on YouTube and across socials so you can rewatch it, share it with your friends. And remember, knowledge is power. So you're getting informed helps you make change. See you soon.